and what could work otherwise for the employers, right? Compulsory recognition of trade union. I think that could be a problem, but I think the employers will automatically get used to this, but they may have to set in a proper process for that. Then the element of subjectivity and room for interpretation. I would say the beauty of the subject, right? Again, the labor law is one branch in the broader subject called law, right? The beauty of the subject itself is in its interpretation, right? So that will continue to be there, but that is the interesting part. I would say it is more with respect to the definition portion, section 2. So who is an employee? See, maybe when we actually do the compliance work, we may fill up a lot of forms for maybe registers or the returns or any application, right? So maybe they would have just mentioned name of the employer. Then we must know for that particular purpose who an employer is, who can be considered to be an employer, right? So their interpretation is required. So I think we may have to resort to automatically the provisions of section 2, which is the definition part as far as the labor laws are concerned, right? In codes also it is there, section 2 only. It describes the definitions of various terminologies used. But that is the interesting part, beauty of the subject. Then two things: containing anomalies and increased financial commitment. I think I have two separate slides for anomalies. I would say, I think when we discussed last week, remuneration payable under any award or settlement. I'm not again very sure. I'm not very clear, honestly, because I think settlement is happening between managements and unions at least once in 3 years, 4 years, or 5 years, not more than 5 years. But why that is getting excluded from the definition of the term wages? What exactly is meant by this phrase? I'm not very clear. So I think some clarity is required. And calculating total remuneration. So what is total remuneration? Is it the monthly gross or what we call as CTC today? Because I think the employer's contribution towards PF and the annual payment of bonus, that is all included there. That is the reason I think we get this doubt. So I think some clarity is required by way of notification or maybe guidance from the department concerned. That would be helpful for the industries to go ahead properly with compliance activities. And applicability of the bonus chapter. I said, in fact, when we discussed last week, so it appears that threshold limit of 20 must be there for every accounting year. Currently, it is not the case. Once it becomes applicable, the Payment of Bonus Act, subsequently, if the threshold limit falls below, the Act will continue to apply. Right, but I think if we go through the wordings of the current code, it does not appear so. It appears that every accounting year, at least for a single day, the minimum threshold number of 20 should have been employed. Otherwise, it looks like that payment of bonus will not be applicable for that particular accounting year. Then applicability of contract labor chapter. Again, I said, I think it is under occupational safety. In the applicability portion alone, they have mentioned that it is applicable to manpower supply contractor. They have missed out the job contractor. Again, I'm not very sure whether that is intentional or some error is there, right? Because when they prescribe license, it is prescribed for both the classes of contractors. Similarly, in the definition part, it includes both the types of contractors, job contractor as well as manpower supply contractors. But only in the application part, they have very clearly mentioned it as manpower supply contractor. I don't know why. And common license for contractors, again, the point is the feasibility is a question, right? When we say contractor, he is not independent. A contractor in relation to an establishment. So when we say contractor, we have to presume the existence of an establishment in the first place, right? But how can a common license be given when the particular contractor has operations in more than one state? That is what this particular provision says. It should be related to actually the same establishment. If the establishment has operations in multiple states, and if the same contractor provides service to that establishment in multiple states, then he can have a common license. That I understand. But I think that clarity again is required. Then common license for factories, contract labor, and BD and cigar establishment. Again, I wonder how can this be combined? Because when we say license for factory, it will be obtained by the occupier, right? The board, right? And when we say license under contract labor, the application will be made and it will be applied, obtained by the contractor. So when you combine this, who will make the application? Let it be online or manual, whatever it is. But who has to make the application? Because one is for the establishment, another one is for the contractor. I'm not very sure how can this be combined, right? Then apprentices other than engaged under apprentices, I think we saw for the definition of the term employee, it excludes specifically apprentices engaged under Apprentices Act. What about the other apprentices? Apprentices engaged under the standing orders, apprentices engaged as per the policy of the company, whether they are to be treated as employees or not. I think these are all certain areas, some anomalies or ambiguities are there. I think if that is clear, then I think it will be easy for the employers, I would say.